began 25 years ago, the preview was an opportunity for law professors and journalists to talk about the Supreme Court. And over the years, we've expanded. We now have advocates, federal court judges, and indeed, this year we have a dozen advocates who've argued about 300 cases before the court. One of them is Walter Dellinger, who's going to get us started this year. But Walter, you haven't quite.
Oh, I'm sorry.
Although I guess I should say Walter, a man who needs no introduction. And so I won't give you much of one, which is to say Walter has been here from the beginning. Lyle Denniston as well, Linda Greenhouse, David Savage. I think all of those folks have been here pretty much every preview, and many of our panels have been here almost every preview. And Walter, when he began at the preview, was teaching at the Duke Law School and had not argued at all before the Supreme Court. And now, 25 years later, Walter has had a tour of duty as the acting Solicitor General and is now partnered with Melvin E. Myers, has argued many cases before the court. And in some sense, the arc of the preview and the arc of Walter's career are somewhat similar. We started out mainly as an academic conference, and over time became much more of a conference where Supreme Court advocates talk about the court to our audience. So, Walter, we're delighted that you can say a few things about the preview and get us started.
Well, thank you. A quarter of a century ago, when the preview was first held here in the fall of 1988, it was a bruising time for the Supreme Court. It was the first term after the cataclysmic battle over the nomination of Robert Bork, President Reagan's third nominee to the court, whose nomination was rejected by a vote of 58 to 42. Justice Kennedy was seated for his first term of the court. And I think this was a particularly auspicious time to try to have a civil discourse about the court and the cases before it among people who took different views but were almost always willing to listen to one another's viewpoints. I think it was not an accident that in the aftermath of the enormous battle over Bork that the American Society of Newspaper Editors had joined with William and Mary in first putting this on together, given the enormous public interest that was in the court. As I look back over those 25 years, it seems to me that they fall into two periods of roughly a dozen or so years. The first 12 years that I was here to do this with Linda and David and Lyle and the others who joined soon thereafter, there were lots of important cases. We went through the abortion cases, Webster, Croson on civil rights, flag burning and religion cases. We had memorable moot courts here, Russ versus Sullivan. I think I argued against Bruce Fine. Clinton against Jones was argued, and the esteemed panel of journalists voted 6-3 in favor of President Clinton's position, which was 6 more votes than I got when I argued that same thing. I didn't find actually particularly helpful. It seems to me that something changed in the with the conference in October of 2000. It looked to be a relatively not greatly newsworthy term. I think the most significant case that we had to discuss as we met in the fall of 2000 was the Texas football school prayer case. And little did we know, as we anticipated, that this would not be a particularly memorable term, that it would produce Bush versus Gore. And it seemed to me that that represented something of a pivot point. After Bush versus Gore, the positions of Chief Justice Rehnquist and Justice O'Connor were filled by the nomination of a Republican president. And so that has been something of a turning point, I think, in the court from that term. There continued to be cases that were memorable in the way that previous cases had been. I think of cases like Heller versus the District of Columbia, the Louisville and Seattle school desegregation cases, more cases on abortion. But the court's docket now has taken on cases that address matters of enormous national significance in terms of decisions of the National Congress. The regulation, the national regulation of campaign expenditures for elections for president and other federal offices, the Affordable Care Act, the Voting Rights Act, national immigration. These are matters of enormous, immediate, practical, and overwhelming political consideration, so that as we evolve in this conference, I think we see more than it appeared to me than the first dozen years before the fulcrum of Bush versus Gore, how enormously important this has been. My own sense, having come as a professor and then returned as an advocate, was to talk to David Douglas and Neil and the others about how valuable the perspective of advocates would be. And that has been, and particularly with the addition of judges, like Judge Wilkinson last year, Judge Wood this year, and so many others, it has been, I think, an enormously enriched conversation. Always the hospitality of the students at William and Mary. I think we've all come to have enormous regard for the faculty of William and Mary, for the wonderful job that Melody Nichols does, to the leadership of Neil Devon. So as we look forward to 25 years from now, some of you will still be around. There'll still be one overarching question, which is, do we think the fact that the Supreme Court plays such a pivotal role has and will and does in American life, on balance, a good thing or a bad thing? My answer at this point would be what Joan Lai said when he was asked by a French journalist what, in Joan Lai's view, was the significance of the French Revolution. And his response was, it's too early to tell. So with that, I will don my cap for the 25th and wish happy anniversary to the Supreme Court preview. Thank you.
So we start the preview, as always, with the Moot Court, and this year, University of Texas, a case where the court will again consider whether a public university can take race into account in making admissions decisions. I'm just going to say a couple things about the case to give you a little background before we start the moot. So the University of Texas seeks to expand racial diversity in two ways. One is through a legislative mandated diversity initiative where the top 10% of each Texas high school gets their students automatically admitted, if they so choose, to the University of Texas, and about 80% of UT students are admitted that way. For the remaining 20%, race is one of several factors that the University of Texas can take into account when making an admissions decision. In 2008, Abigail Fisher was denied admission to the University of Texas, and she challenged the constitutionality of the Texas plan. She claimed, essentially, that the 10% plan, a race-neutral plan, was all that the university could do, and as a result, the court should reject the plan for its race-conscious aspects. The Fifth Circuit rejected her argument in January of 2011, and they said that a 2003 Supreme Court decision, Grutter against Bollinger, allowed the University of Texas to take race into account so long as it was done in an individualized way. In June of 2011, the Fifth Circuit rejected Fisher's en banc appeal, and Fisher then went to the Supreme Court, asking the court to either overturn Grutter or alternatively say that the race-neutral 10% plan was the least restrictive means to satisfy the state's interest in racial diversity. On February 2012, February 21st, 2012, the court agreed to hear the case, and on October 10th, the court will hear oral arguments in the case. So with that little bit of background, we'll now start our moot court.
All rise. Okay. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. All persons having business before this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and his honorable court.
The court will now hear arguments in number 11-345, Abigail Nicole Fisher versus the University of Texas at Austin. Ms. Wax, I understand that you want to reserve 5 minutes of time for rebuttal.
Yes, I would.
Thank you.
Ms. Chief Justice, and may it please the court. The University of Texas use of race in its undergraduate admissions process and for special programs at the University of Texas fails the strict scrutiny standard that this course has repeatedly embraced for race-based official action in its prior cases, including the Grutter v. Michigan case. Texas must demonstrate a compelling interest in using race as an independent factor in admissions, which it admittedly does, and it has not done so. First, the use of race to add to educational diversity at UT is not a compelling state interest in the context presented here. Why is that? UT already has its so-called 10% plan, whereby it accepts the majority of its students from a group that ranks in the top 10% of their high schools across the state. And Texas has already achieved considerable diversity across a range of dimensions, including race.
Can I ask you a question? If they didn't have the 10% plan, would you be challenging what Texas otherwise does on the admissions?
Well, I would generalize that. If they didn't already have some mechanism, and there are lots of potential mechanisms.
So if they just had an outreach program, you'd say that anything beyond that would be unconstitutional?
Well, once again, it would depend on what they achieved with their outreach program. It's quite striking how much we've learned in the 11.
What is
yes.
So then what is the benchmark of achievement? What do you need to say, okay, that's enough?
Well, that's really the question for the other side, we believe. The critical mass concept, we think, is extremely squishy and manipulable. That is the sort of buzzword that the court has seized upon. Our view is that critical mass—
That means that's the question for us.
Yes,
more than it is for
yes,
them.
indeed. We really have no clue as to what critical mass means. It clearly means something other than utter uniformity.
But Counselor, you must, because you say that the top 10% achieved enough. And we're asking, if you say that, how much is enough?
Well, we're saying that the other side hasn't demonstrated that the top 10% doesn't achieve enough. And we believe that it's incumbent on the University of Texas to articulate a particularized standard, something a little bit less squishy and vague and amorphous than just the invocation of this phrase, critical mass.
Well, if they did something less squishy, you would criticize it as, you would say they're standing for quotas. I mean, is it for this court to second-guess the university, given that Grutter, I take it, is still good law, and tell the university how much is too much, how much diversity is too much?
Unfortunately, there's really no other way to do it. It is true that Grutter said that diversity is a compelling interest in the educational context, and that some degree of deference should be applied to the judgment of educational officials, educrats. But I think our 9 years, our 10 years of experience with Grutter has shown that there is a kind of internal contradiction here between the individualized assessment, which allows a university to put any weight it wants on race through its black box processes without question, and the idea of strict scrutiny. Strict scrutiny means that there has to be a hard look.
Can you be specific as to what's happened in the last 9 years? I mean, what empirical evidence are
Yes,
you
Your Honor.
talking
Yes,
about?
Justice Phillips, I will be very specific. What we've learned is that it is possible to achieve a fair degree of racial and diversity on many dimensions without having a race-conscious program. We now have 7 states that have outlawed race as a basis for choosing in their state university systems, students in their university systems. That represents 40% of the American population. And a recent study by Carnival and Rose, shows that those university systems have achieved racial and other diversity and a mix in their undergraduate populations that approximates what the states that have used race-based affirmative action programs also achieve. So there is a negligible difference between what can be done with race-neutral means and what has been done using race. And I can detail for you some of the race-neutral means that have been extended. First of all—
Ms. Wax,
yes.
isn't the flip side of what you just said, you talk a lot in your briefing, you just said that there's a negligible impact when you start using race on top of the percent plan. But isn't the flip side of that they're not using race as much as the University of Michigan was in the Grutter case? So shouldn't we applaud the fact that Texas has found a way to use race less? They use the percent plan for part of their class, and they use race for a quarter of their class.
Well, that's like being a little bit pregnant, Justice Stohr. The use of race in and of itself is the gravamen here, is what requires a compelling interest. Now, in order to show the compelling interest, once you just step over the line and start using race, even if you use it a little bit, right, you have to show some substantial benefit. There is something that is being gained that is absolutely essential, that is absolutely necessary to meet whatever goal is being posited. And we would submit that there's no gain here. There's almost nothing, and there are lots of detriments.
So to follow up on Justice Stohr's question, is there any way that Texas, consistent with Grutter, can use the top 10% plan and then consider race?
We don't think so, Your Honor. We think the 10% plan does the job as well as is necessary to meet this very elastic and amorphous standard. And remember, the standard here is educational benefit, not proportionality, not mimicking the population, mirroring the demographics. There is absolutely no reason to believe that there is any relationship between mirroring the demographic.
The data that the state puts forward that suggests that there are a significant number of classes in which you'll have a single minority.
Right.
Why can't they continue to move in the direction of trying to resolve that problem?
Well, the first thing we'd say about that is that it's now completely unclear how much respondent is relying on the class-level lack of diversity as a rationale for its PAI file, individualized assessment. They seem to have retrenched from that, but I suppose that's a question for them. To the extent that they do use it and they do rely on it, and in fact it is cited as one of the reasons for adopting the race-conscious plan in the wake of Grutter, we think that it's very dangerous and very, very threatening, we think, to the sort of neutrality that we would like to see. And the reason is as follows. It is an objective that has no limits. Right? It licenses a tremendous amount of intervention, giving an enormous amount of weight to race in order to achieve the mix at the classroom level. Right? Because there are many programs and many classes at UT that do admittedly have few or no minorities. Now, what is the reason for that? The reason for that—
I'm just trying to connect that with the findings in this case. Are you saying that what Texas does now is an intrusively race-based decision-making process?
Well, yes.
It goes back to the question I asked you. If you took the 10% out of the mix, what Texas is doing now sounds an awful lot to me like sort of Michigan, except that if Justice Stohr's right, it's a little lighter than Michigan.
Yes, but just doing it a little bit doesn't complete the analysis. It has to advance a compelling state interest. And our position is that this interest is not compelling because they already have 98% of what they need on any sensible notion of pedagogical benefit. Right?
Are you asking us, in effect, to put Texas to a choice that they can do top 10 if they wish, they can do holistic if they wish, but they can't do both?
Sure. I think what we're really saying is that we've learned since Grutter that it is possible to achieve diversity across many dimensions without using race, period. We have learned that. We didn't perhaps know that at the time of Grutter. Experience has taught us that. Indeed, we can acknowledge that Grutter says that race can be justified by a compelling state interest, and at the same time see that when you're doing university admissions, there will almost never be a compelling state interest because there are other alternatives. This is part of the narrow tailoring analysis. The narrow tailoring analysis tells us that we don't need race.
Isn't the 10% plan a racially conscious plan? It's just is not transparent about it. The plan would not be have been adopted and would not achieve diversity except for the fact that the high schools in Texas that generate the top 10% are themselves very undiverse.
Right. Well, Justice Greenhouse, here's how I would put it, is a contingent fact about Texas that it has a fair degree of segregation in its high schools. That is a contingent fact about Texas. Indeed, it's a contingent fact about our world and our country. Now, it doesn't matter that that's a contingent fact. We can build diversity in university admissions on that contingent fact. Maybe 10 years from now, or to quote Justice O'Connor, 25 years from now, that contingent fact will no longer obtain, and then we'll have to use other techniques. Perhaps no other techniques will suffice, and we'd have to go back to race. But there are, of course, myriad other techniques that the 7 states that have outlawed race-conscious admissions use and achieve a fair degree of diversity. There are a lot of other criteria.
Ms. Wax, I was surprised by your answer to Justice Liptak. He asked you if Texas has a choice. Are you saying that Texas, in spite of all the evidence you're about to read off there, could actually just say, no, we're not going to use the 10% plan, we're going to go back to entirely holistic review with race, just like the University of Michigan did?
I'm sorry. If I said that, I misunderstood your question. What I am saying is that Texas, in effect, doesn't have a choice to use a race-based plan. Texas can choose between a 10% plan and other techniques that have been shown to create diversity. It could, for example, focus on attributes like family background, like family structure, like first in family to go to college, income, wealth.
So that's a direct assault on Grutter then, right? I mean, that's a direct assault on Grutter.
We'd have to overrule
We'd have to
Grutter.
overrule Grutter to accept your position. Is that correct?
Well, here's how I would put it. I think that our position and what we've learned since Grutter seriously erodes the footprint of Grutter. It shows us that Grutter barely ever applies to licensed race-based decision-making. That's what it shows. It really renders Grutter a dead letter rather than overruling it. I think to the extent that we have to seriously reassess Grutter, it would be in the kind of asking for a firm basis in evidence for thinking that any particular increment or any particular number of people from certain groups add to educational benefit. Grutter does suggest a great deal of deference. It is our position that that deference is inconsistent with the kind of strict scrutiny that is necessary to satisfy the well-established constitutional standard. In effect creates a black box, and we have a black box here. Nowhere in the briefing, and I have read looked at every one of these 94 briefs, does Texas say exactly what weight is assigned to race, how it sort of puts the sausage together. It just says it has this kind of holistic process. Bingo, comes up with a number and then puts that number on the grid.
But wasn't that the instruction from Grutter?
Yes, but I think we've learned that that instruction and strict scrutiny are incompatible.
So we'd have to overrule that part of
That
Grutter.
part, I think, is
And the
has
deference
to go.
part.
Yes.
And
yes,
the
Your
deference
Honor.
part too. Okay.
What would be
Or
left?
be seriously reassessed.
What would be left under your formulation of Grutter?
Oh, what would be left is the possibility of using race if the users could articulate a target benchmark standard for educational benefits, something really hard, something we could hang our hat on. We could measure it, we could look at it, we could track it and follow it, but we do not have a concept.
Like, that sounds a lot to me like what was going on in the undergraduate case at the University of Michigan, right? Like tracking with numbers, the Gratz case, the case.
No, tracking, no, I'm not talking about tracking the numbers of minorities. I am talking about tracking or putting a meat on the bones of the concept of educational benefit, of pedagogical benefit. The court in Grutter said diversity, race-based decision-making to generate diversity can be used if the diversity produces educational benefit.
Is that within our institutional competence to decide? Is that a judicial decision?
Well, I think it is. I mean, the fact is the court all the time looks at whether facts meet a legal standard.
Ms. Wax, do you
Educational
really want
benefit's
to put
pretty
us?
simple.
Do you really want to put us in such a bad place here, between a rock and a hard place, in terms of saying that we really have to cut back on Grutter so dramatically in less than a decade? Is that the only way you can win this case?
Once again, experience is a teacher. We didn't know a lot of things at the time Grutter was decided that we know today. We did
The evidence is so in conflict on that.
So here's here's something we know today, from at least from reading the state's brief. So we know that at the classroom level, in certain majors and certain types of classes, there's almost total lack of diversity. We know that many minority students in the top 10% accept offers to go because they're strong students. Let's posit math and science students. They're strong students. They accept offers to go out of state. Probably scholarships to go to Ivy League schools are very desirable as students. And so Texas looks at this situation from experience and says the 10% is creating, the way it's working in the real world is creating a situation where we have math and science classes that are all white. And that's not a good educational environment for the minorities who aren't there, or the white students who are there and look around and say, gee, I guess, Blacks and Latinos don't do math and science. So we're going to tweak the 10%. We're going to holistically invite into our university students who can fill that gap. Isn't that part of experience?
Well, Justice Greenhouse, I mean, there's a lot there. First of all, there is a kind of nationwide problem, and let's take judicial notice here, that minority students are seriously underrepresented in math and science. Right? And if you're talking about a compelling state interest in getting them in there, a compelling state interest means that we're going to generate a benefit. But if we generate a benefit, we also have to look at the downside and the detriment. There's a lot of data that shows that if you use race very heavily to get minority students into math and science courses in universities where they are mismatched by ability with most of the other students who are there, that has detrimental effects. That can actually have downsides that can hurt the minority students. And the evidence for that is no stronger and no weaker, right, than the evidence, which is virtually non-existent, that there are concrete educational benefits.
Shouldn't that be a call for the educators to make?
Well, unfortunately, it can't be a call for the educators to make when we're talking about strict scrutiny, the use of race. If we license educators to make that call, then they will be licensed to look at only one side of the equation. And indeed, the briefs for respondent exemplify that. They're all about the so-called benefits of diversity, and nowhere do we hear about the costs and the downsides of diversity, the ways in which both majority and minority students can be hurt by the kinds of interventions that would be necessary to get the so-called critical mass of Black and Latino students in science courses.
Are we behind that, beyond that now, given what we said in Grutter? That isn't the point to look at the benefits of diversity and look at the actually what's happening in the classroom for things? I mean, it seems like you're trying to take us back way before Grutter at this point.
When one is looking at, first of all, benefits are always net benefits, right? One cannot just look at one side of the equation. If there are benefits of diversity, then they have to be balanced against the detriments of diversity. And once again, if it's just the say-so of educational officials that these so-called benefits exist, and the benefits are very vaguely defined, they haven't been quantified, they haven't been tracked, the empirical data is a mess or non-existent, right? Then that is a carte blanche. That is just perfect. It is inconsistent with anything like strict scrutiny. Think about it. The firm basis and evidence standard has been adopted for remedial affirmative
I don't understand why that's carte blanche, because it may say that we'll be deferential in determining whether or not a compelling state interest applies. It doesn't say anything about the standards we're going to apply for narrow tailoring.
Well, if Justice Greenhouse says that we need diversity at the classroom level, right, we're going to have to dig deep
well, how do we know
down
that? How do we know that? How do we know that? I mean, is the experience in Texas clear that with the additional add-on beyond the 10%, is that something that is a deep dive into race?
To get classroom diversity would require a deep, deep dive into race, Justice Phillips.
And where is that in the record then?
The record, well, it's not in the record as such. It's based on the SAT profiles that are attached as part of the appendix. For blacks versus, let's say, Asians. So, for example, at the University of Texas, the average Asian has 400 additional SAT points over the average black. And that is, I can't cite you the page, unfortunately. But that is in the record. That would be even more exaggerated if we tried to fill the classrooms. Let me also say...
Ms. Wax, you're going to reserve your time, right? It's Mr. Chemerinsky's time.
I'll have to make this point on rebuttal.
You will. You'll be able to. Thank you.
That was very Rehnquist-like.
I know. We're on schedule. Yeah.
Mr. Chemerinsky, I know you have a lot to say, but I'm just dying to ask a question. Are you seeking a critical mass, and if so, of what?
Yes, Your Honor, the University of Texas is seeking a critical mass, and is particularly seeking a critical mass of African American and Latino students that statistics show are underrepresented.
Combined
no,
or
Your
separately?
Honor, it's seeking a critical mass of African American students and a critical mass of Latino students.
Okay, don't you have, with the percent plan, haven't you hit that, whatever the critical mass is, haven't you hit that? I mean, that's up, the percent plan, I think, gets you like upper 20s Hispanic students, right?
No, Your Honor. In fact, what the University of Texas found was that the number of African American and Latino students decreased under the top 10% plan to what it had been in 1996 before the Hopwood decision. In fact, I can give you the exact statistics on that. The number of African American students in the fall of 2002 were 3.4% of the student body, and for Hispanics, it was 14.3% of the student body, significantly below the 1996 level. That's why the University of Texas, following the Grutter decision, adopted the holistic review for the other 15% of the student body not admitted through the top 10% plan.
But not today, right? Under the top 10% plan today, the percentage of those students who are admitted is much higher than that. It's in the 20s of Hispanics. Putting African American students aside, because I understand how the critical mass argument works there, I don't understand how it works with regard to Hispanic students, given how successful they are at getting into the school through the percent plan.
Your Honor, when you consider Hispanic students in Texas, you have to also consider the tremendous increase in the Hispanic population of Texas. Relative to the population of Texas, the number of Hispanic students through the top 10% plan is less than it was in 1996.
But that sounds like that's racial balancing, right? I mean, that's what we said you can't do. We're talking about the critical mass talks about the internal benefits of having enough members of a particular race on campus in classrooms so that they're not feeling like individuals.
That's correct, Your Honor. The idea of critical mass
they're
was
not
first,
feeling like representatives of their race, but instead are individuals.
The critical mass notion was first articulated by Justice Powell and Bakke and repeated by Justice O'Connor's majority opinion in Grutter. And both in Bakke and in Grutter, critical mass was never defined, and it can't be defined. But what we're suggesting is one way of looking at critical mass is having a university that basically reflects the population of the state, so those in the state would feel comfortable in the university, want to apply. One of the key things here is the statistics show...
I just want to make sure, that's your standard? You have to essentially track
no, Your Honor, because that would be
the
racial
percentages
balancing.
in the state?
I'm just saying that one way of looking at critical mass is how it is relative to the population of the state. Does the university
wouldn't it make more sense if you were going to actually do an analysis of critical mass for Texas to go and talk to the students and ask them at this time whether or not they feel reasonably comfortable given the numbers of similarly situated individuals?
One measure would be that. I think another measure is looking at the individual classrooms. As Justice Greenhouse pointed out, if you look at the classes there, you certainly don't find adequate representation of minorities. That's another way of measuring critical mass. Now, I wanted to begin with an argument.
So can I test
Of course.
that? So now you're going to insist that every class in the University of Texas system has at least 2 minorities?
No, Your Honor. What I am saying is...
Can you mix and match Hispanics and African Americans in a single class so you get up to 2 that way?
No, Your Honor, that's not what we're saying. What we are saying is there are many ways of looking at critical mass. One is looking at the individual classes and whether or not there are minority students there. Another is looking at the presence of minority students relative to the population of the state. I'm not arguing either of these is sufficient. but they're both relevant, and both show that under the top 10% plan, there wasn't diversity. But the argument I want to begin with, and I don't want to be lost, is that I think this court should dismiss this case as certiorari improvidently granted for lack of jurisdiction, and that hasn't been mentioned here previously. It's important to note that the only claim that remains by Abigail Fisher is one for money damages. She's seeking $100, $50 for the application that she filed, and $50 for her housing deposit. Unlike Bakke and Grutter, there is no longer a claim in this case for injunctive or declaratory relief. If you look at the petitioner's brief on page 2, it lists who all the defendants are. It's the University of Texas and a group of individuals in their official capacity. Since all that there is in the constitutional claim is one for money damages, and the only defendants are the state and those in their official capacity, sovereign immunity bars this case from going forward on the constitutional claim. Also, under this court's decision in Texas versus Lesage, the plaintiff doesn't have standing. As this court has said, standing requires that there be an injury caused by the defendant, likely redressed by a favorable court ruling. And here, the injury is the loss of $100. Ms. Fisher surely can't show that she wouldn't have applied to the University of Texas without it having the affirmative action plan. In fact, Texas versus Lesage from 1999 draws a distinction between affirmative action claims for injunctive or declaratory relief versus those for money damages. There, this court said if it's a claim for money damages, the individual has to show that he or she would have received the benefit without the affirmative action program.
Are we limited in addressing the injury to just the what she seeks in the complaint? Like, is that it? I mean, like, I'm thinking about Mass versus EPA, and I mean, they're not going to get their land back because of the climate. I mean, are we limited in the injury question to just the damages, or can she be injured by the stigma of being rejected, or?
Texas versus Lesage specifically deals with affirmative action, and it says there's a distinction when affirmative action is being challenged by someone seeking declaratory injunctive relief as opposed to someone seeking money damages. And there, this court said if someone is seeking money damages, they have to show they would have received the benefit without the affirmative action plan. And the summary judgment materials in this case show that even if Abigail Fisher had gotten a perfect personal achievement score, she still would have been rejected by the University of Texas. So under this court's own precedent, the answer to your question is yes. Now, if this court finds that there's jurisdiction, then our second argument is that this court, the University of Texas plan is constitutional under this court's decision in Grutter versus Bollinger. In Grutter, this court held that colleges and universities have a compelling interest in having a diverse student body.
Chemerinsky, just to go back on your standing issue.
Yes,
so
please.
if we in fact embrace that argument, so then we vacate the underlying judgment and dismiss the case?
That's correct, Your Honor.
So the judgment in your favor is
No, we could
wiped
just
out?
dismiss as improvidently granted. We don't have, right? We can just dismiss the petition.
How could we possibly do that? In the face of a claim that we lack Article 3 jurisdiction?
Well, which one do you seek? I would seek the dig, yeah.
I would seek the more responsible Article 3.
If cert is dismissed as improvidently granted, it will still return to the lower courts, and the lower courts, if they find that there's a lack of standing, cannot give any relief in this case. There is no standing, so in that way, the judgment of the lower court has to be vacated. Also, the judgment can't stand for money damages because it is a monetary claim, and only a monetary claim against the state of Texas and officials in their official capacity. The case has to be dismissed based on sovereign immunity.
Of course, if there's any claim that was capable of repetition, it would be Ms. Fisher's claim, because the legal outfit that ginned up her case would certainly, there's probably plaintiffs waiting in line that they could pull on.
No, Your Honor. In Honig versus Doe, this court said in order to claim that it's a wrong capable of petition but evading review, there has to be at least a possibility that the plaintiff would suffer the injury again. Ms. Fisher has graduated from Louisiana State University. She can't suffer the claim again. The way in which the petitioners have tried to avoid the mootness issue is by making it entirely a claim for money damages. But by making it a claim for money damages, they then fall prey to both sovereign immunity and Texas versus Lesage. Now, in terms of the second issue, the merits, Grutter versus Bollinger said that college universities have a compelling interest in their diverse student body, and college universities may use race as one factor in their admissions decisions to benefit minorities. That's exactly what Texas is doing. Ms. Wax, when she was up here, just said that ultimately she's calling for the overruling of Grutter versus Bollinger. First, her argument is outside the scope of the question presented at this court. The question presented, if you read petitioner's brief, is that the University of Texas program is unconstitutional under existing law. But there's an even graver problem with the argument she made, and that goes back to the complaint that she filed in the court. This court made clear, most recently Christian Legal Society versus Martinez, that parties are bound by what they say in their pleadings and their stipulations. And the second amended complaint filed by Ms. Fisher, paragraph 145 says, to the extent that UT Austin articulates an interest in promoting student body diversity, plaintiffs do not challenge this interest. She is bound by that. No arguments to the contrary can be given any weight. We believe that this court in Grutter recognized that diversity is a compelling interest. And the regents of the University of Texas, articulating this policy, said that their goal was diversity. The proposal with regard to holistic review said the goal is diversity.
But counsel, does that give you unfettered latitude to achieve that goal in any way you wish?
No, of course not, Your Honor. But what I think Ms. Wax fails to do is separate two questions. Is there a compelling interest, and are the means sufficiently narrowly tailored? I think under Grutter, there's no doubt there is a compelling interest. And under paragraph 145 of the complaint, there's no doubt there's a compelling interest. So then we have to shift the analysis to, are the means sufficiently narrowly tailored? And what this court said in Grutter is race can be considered as one factor in admission decisions. That is exactly what the University of Texas does. Admission is based on two different scores that are put in a matrix. One of these scores is the academic index. The other is the personal achievement index. The personal achievement index is a function of two things. One is two essays that are graded. The other is a personal achievement score that's 7 factors. Race is one of the 7 factors.
Mr. Chemerinsky, Ms. Wax complained about this as a black box system. Can you articulate precisely how race plays out then in a specific case?
No,
or do we
Your
know? Do we know to a moral certainty that you have all 7 factors, but if the African Americans in there, that immediately is the basis on which somebody gets slotted into a spot?
No, Your Honor. And if it were possible to do that, then we would run afoul of what Justice Powell said in Bakke and what this court said in Grutter. Both Justice Powell and Bakke and this court in Grutter said that race should be used as one factor among many in a holistic appraisal. The University of Texas patterned its system exactly on what this court said in Grutter. Now, what we can, I'm sorry.
Counsel, I'm still having trouble understanding what your goal is here. You said Ms. Wax essentially conceded that you have a compelling interest in diversity. But I think her next argument is, and you've achieved that compelling interest because of the 10% plan. Look at the numbers. Very successful.
No, Your Honor, as I said in your initial questions, the number of African American and Latino students in 2004 was less than it was in 1996, and for Hispanics, substantially less if you take into account the increase in the Latino population in the state. Now, what Ms. Wax tried to argue here is that this program uses race too little unless it's unconstitutional. Now, that's ironic because in all of the other affirmative action cases, the challenger said it used race too much. But I think this goes to Justice Phillips' question from a moment ago. I think you can see that this does make a difference overall, though we can't know which cases. Let me start with applications. The number of applications by African Americans increased substantially. The number of African Americans by Latinos increased by 1.5 times after Texas adopted this program. The enrollment of African Americans doubled as a result of this program. And we have specific statistics. Of 728 African Americans admitted in 2008, 20%, or 146, was a result of the holistic review program. So that shows that the holistic review does make a difference. It's not too little a factor. Now, the question that you ask is, how do we decide what's critical mass? Here I think Grutter says there does have to be some deference to educational officials in deciding what's diversity within their university. And here the University of Texas does present the statistics, like those Justice Greenhouse points to with regard to the classes, or overall statistics about the decrease in the presence of African Americans and Latinos prior to the 10% plan, all of which shows using race as one factor among many admissions does have a benefit, but is also consistent.
If we defer in that way, how can that be consistent with strict scrutiny, or are you arguing for a lesser standard?
Your Honor, I am not arguing for a lesser standard. I am arguing for strict scrutiny. And I here go back to what the court said in Grutter versus Bollinger.
But let's pretend I think that Grutter was wrong. And I mean, let's think that I just feel like maybe it's on the table. Let's just hypothetically think that. Okay. So then do you think strict scrutiny is still compatible with deferring to the university?
Your Honor, strict scrutiny is still the test. I think that strict scrutiny does not preclude deferences to some specific questions by the university. In fact, Justice O'Connor's opinion in Grutter specifically talks about deference to the university. Where is deference appropriate? I think in the determination of what's a critical mass within the university. That's not a concept that's going to ever be able to define with precision. The very concept.
Let me go back into that, because as I indicated in my question to Ms. Wax, that part of the record, the proportion of minority students admitted under the 10% who don't accept UT's offer of admission and who get picked off and go elsewhere is really striking. I mean, it's a substantial proportion. So isn't there something that UT can do to induce those highly accomplished and highly desirable minority students to stay in the state? Some kind of special aid or something, some kind of inducement that would achieve what the 10% plan in theory ought to be achieving is failing to achieve, and would save you from having to go this other mile.
Your Honor, what you just suggested might be scholarships that specifically go to minority students. I think that would be unconstitutional under this court's decision in Grutter. What's important, and what Ms. Wax doesn't focus on, is that the University of Texas at Austin tried many alternatives. It tried the top 10% plan. It also tried creating recruiting centers throughout the state. The district court found here, and it's important to note, and I quote, "To argue that UT has failed to give serious, good faith consideration of race-neutral alternatives is to ignore the facts of this case." And I think this court is bound by that judgment of the district court, that they've tried the race-neutral alternatives, and it's only through the holistic review that they're able to achieve the larger presence of minorities. What they determine within their judgment is critical mass.
What do you do with the data that Ms. Wax adverted to, that over the course of the last 9 years, there is a substantial body of evidence that suggests that these kinds of these more race-conscious affirmative efforts are no longer necessary, and that you can accomplish exactly the same thing through non-race-conscious means?
Your Honor, the relevant evidence in this case is that which concerns the University of Texas. Texas has tried race-neutral alternatives. And what Texas found when it was using race-neutral alternatives was that there was a substantial decrease in the presence of African-American and Latinos in the state.
Something unique to Texas that makes it less capable of accomplishing this than every other state in the union?
Your Honor, the record doesn't document that, but nor does the record include the data that Ms. Wax is talking about in terms of the other states. It may very well be that there's something different in Texas in terms of the demographics of the state that cause these other alternatives to fail.
So we're going to have a special rule for Texas under the 14th Amendment, and all the other states got to get in line?
No, Your Honor. The issue before this court is whether the University of Texas policy is constitutional, and whether under the record of this case, Texas has sufficiently shown that this program is justified. And the conclusion I think you have to come to is that under Grutter, diversity is a compelling interest. Texas said all along that's its goal, and that Texas, as Grutter says, using race as one factor. Race has had an effect that couldn't be gained through a race-neutral alternative.
Mr. Chemerinsky, let me add to that question on the other data that she points to in terms of detriment, the downside of diversity and the mismatch factor. What kind of consideration need the court even give to that?
Well, here I think is the argument that some students would not get in because of the program. It's interesting that the statistics really showed the extent to which race is just one factor. For example, the statistics with regard to the summer program, I think, directly address your question. In the summer program, there was one African American, and there were 4 Hispanic students who were admitted with lower than what would have otherwise been their numbers. There were 42 Caucasian students and Asian students who were admitted, who had numbers lower than that. At the same time, there were 66 African American and Hispanic students who were rejected, who were higher than that benchmark number. So what his holistic review is saying is that for every student, and this includes white and Asian students as well as African American Latino students, all of their life experiences are taken into account. So Asian students and Caucasian students, like Black and Latino students, benefit from holistic review. It truly is, as these statistics indicate, a holistic review.
Even if that's true, doesn't there still something about the presence of the race-conscious policy, even if the stigmatizing message that it sends, that violates the 14th Amendment?
No, Your Honor. This court in Grutter rejected that argument explicitly. This court in Grutter did not say that colleges and universities must be colorblind. This court did not say that college universities can never look to race. Quite the contrary, this court emphatically held that college universities have a compelling interest in diversity and may use race so long as just one factor in admissions. And you can't see a program that more than this one meets that, because race is just one factor of many that's used in the admissions process.
Counsel, I want to go back to your assertion a few minutes ago that this court should defer to the university's assessment of what is a critical mass. Do you mean that literally? Do you mean that there is no constraints on the university's conception of what would constitute a critical mass in terms of race? Zero constraint.
No, Your Honor. Deference never means abdication. What it does mean is that there are places where educational officials are in a better position to make determinations than this court is. And so when a university comes to you and says...
So can I test that? What's the basis for the university's determination that you have to have two African Americans in every classroom?
Your Honor, the university never says you have to have two African Americans in every classroom.
Well, pretty much sounds like that's what you're saying.
No, Your Honor. What the university does is point to statistics
you're saying if you have one,
show...
then we can continue to say there's no critical mass. I mean, and we have to defer to that.
No, Your Honor. If you look at classes, say classes below 25 students across the University of Texas, and they average either 0 or 1 African American, that shows a lack of critical mass. That doesn't mean that every class has to have 2 African Americans. It does show a lack of critical mass within the university. It's one measure.
I mean, it's all well and good to say it shows that there's a lack there, but the flip side of it means that you can continue to engage in consciously race-based decision-making until you get 2 students in every class.
Your Honor...
Because you're asking us to defer to your judgment as to when you've satisfied the critical mass determination. And I can't, you tell me where between those 2 extremes I get to step in and say something different than what you say.
The concept of critical mass comes from this court. And this court didn't define critical mass.
Well, I'm trying to now.
But, Your Honor, I think it's a concept...
That's because they didn't do it 9 years ago. There's no reason we can't get to it now.
No, Your Honor, I think this is a concept that can never be defined in numerical terms. As Justice Stohr said, critical mass is about having a sufficient number of African American Latino students.
Well, that's why I asked you the question. Why don't you just go ask the students whether they think they have a critical mass? And if they say they do, then we're done.
But, Your Honor, while that may be one way of assessing critical mass, this court has never suggested that's the only way of assessing critical mass. And critical mass can be measured, as I've tried to say here today, in many different ways.
Hey, but one of which is purely racial balance to the demographics of the state. I'm pretty sure that's not the one I'm going to embrace. So what else you got?
So, Mr. Chemerinsky, so long as you keep reciting this formula that it's one factor among many, we have no work to do. There's no point at which you're putting your thumb on the scale too heavily, so long as it's one factor among many.
Well, this court in Grutter said that race can be one factor among many, and that's exactly what the University of Texas is doing, and that's why what Texas is doing is clearly constitutional under Grutter versus Bollinger.
Mr. Chemerinsky, are you seeking a critical mass of Asian students?
Well, by every measure, there is a critical mass of Asian students. If there wasn't, then the University of Texas would.
Aren't there fewer Asian students than Hispanic students?
Well, but if you go back to the population of the state as one indication of critical mass, the percentage of Asian students is much greater than the population in the state.
So the whole bit about diversity within the classroom, what Justice Phillips was talking about, that's out the window, because that really isn't the fact. That's not driving the bus here. Because if it was driving the bus, you would be as concerned about the number of Asian students in each classroom as you are about the number of Hispanic and Black students, right?
Your Honor, the percentage of students in the classroom is very much in play because, again, it is a measure of critical mass. There's nothing in the record that shows that Asian students are underrepresented in the classrooms in the way that African American Latino students are. And the simple reality is that across universities in the country, Asian students are not an underrepresented minority in the same way Latino and African American students are.
I don't understand the word underrepresented. Compared to what? Are you just talking about the state population now?
You could look at the state population, or if there was a claim that Asians were underrepresented in individual classrooms, we could be talking about that. No one has claimed that Asians are, by any measure underrepresented at the University of Texas.
Are there other ways to figure out whether Asians are a critical mass besides looking at their correlation to the population of Texas? I mean, you said that Asians are a critical mass now. How do you know that?
Well, one starting point, and I keep saying starting point, is relative to the population of the state. And Asians in the University of Texas are significantly greater than the percentage of the state. We could also look in the classroom if there was reason to be concerned. The reality is there's never been reason to be concerned at the University of Texas about underrepresentation of Asian students. But African American and Latino students have historically been underrepresented at the University of Texas. This is a university that, through much of its history, refused to allow African American students to attend. And the University of Texas, in seeking diversity, is trying to cure that by doing exactly what this court prescribed in Grutter, using race as one factor as many. Thank you.
Chemerinsky. Ms. Wax, you have 5 minutes left, and you might want to address the jurisdictional standing issue just in case some justices are concerned about that.
Just very briefly, because I don't want to eat up my time. I have so many important things to say. Our submission is that the money damages claim makes this not moot. And secondly, even if it is capable of repetition and evades review, and this standard that it has to happen to the particular individual, that the injury might happen again to the particular individual, is complete make-weight. In many of the educational cases, that has not been the standard. Obviously, people just zoom through college and there's not enough time to complete the cases, so that's very important in this context that we apply that policy. Thirdly, if this court does say that there's no standing and no jurisdiction, we absolutely do believe that the judgment below should be completely vacated. I would like to...
Before you start on your argument, to take it back to the compelling interest issue and make sure I understand your position, which I'm not sure Mr. Chemerinsky correctly characterized. You concede as a doctrinal matter in the abstract that the court has told us that educational diversity is a compelling interest, but you're saying here that that compelling interest has been achieved.
Yes.
In the Texas case, right? So the compelling interest, from your point of view, falls away. There's nothing more to discuss about it.
Correct. There is in the abstract and in general this concept of compelling interest, but it is coupled with a narrow tailoring requirement, and the narrow tailoring requirement says that race is a last resort.
Can you then respond to Mr. Chemerinsky's point that the statistics don't bear out that we are anywhere near a critical mass, that in fact we are worse off in the University of Texas based on the percentage of minorities than we were in 1996?
Well, here's the problem. Define critical mass, right?
I've been trying to do that for the last hour.
What the educational officials say is, trust me, trust us. We don't have enough blacks. 4% is not enough. We need 6%. We need 7%. And our question would be, by what measure, by what benchmark? No, in this argument, we have not once heard what the measure of educational benefit is that we are seeking to achieve with diversity.
Was that measure provided in Grutter?
It was not. Grutter talked in the most general terms, and I think it was contemplated that additional experience and later cases would fill in the blanks, and those blanks have not been filled in. In terms of asking the students...
Well, are we free to fill in the blanks with data from unrelated circumstances that weren't part of the record in this case?
We are free to demand from the institutions that are using race that they come up with something more concrete than they've come up with. Merely asking students is not a good measure, and the amicus brief of statisticians and economists point this out. Students are suggestible. Students are subject to fads and fashions and ideologies. If they are told that there aren't enough blacks, they will believe it, or enough Hispanics. But for what? These facts are in the record. Caltech has 0.9% blacks, Carnegie Mellon 3% blacks, MIT 3% blacks. I would challenge anyone to say that either members of majority or minority or Asian groups get a poor education at any of those institutions. And if that assertion is made, if the assertion is made that those institutions...
Wait a second, but that's not the standard. It's not, the standard isn't a poor education. I don't think anybody's going to carry that weight. What the question is, would they have a more complete and culturally fulfilled education if they had representation to a broader array of people, particularly given that it's probably that is exactly
demonstrate in what way the graduates of those institutions fail of whatever function or mission the educational institution is equipping them for. It's that specific, Your Honor. It is otherwise, we have a degree of deference that basically allows educational officials, educrats, to say whatever they want and assert whatever they want without any limit and without any burden of proof. And that just is inconsistent with strict scrutiny in our view. I would add in my remaining time that the strong basis in evidence standard, which the court admittedly did not expressly embrace in Grutter, but has in prior cases like Rickey and Adirond and Crozon, has been applied in the remedial context where, if anything, the interest is more compelling and of greater provenance and strength to correct past discrimination is a core recognized goal of using race-based decision-making, whereas diversity is a recent add-on. So we should have, if anything, a stricter standard for what we're doing here than the one that we've embraced in remedial cases. Thank you.
Thank you, Mr. Chemerinsky. The case is submitted. The court will take a 15-minute break to vote on the case and come back and announce our decision. Thank you, everyone, and especially thank you, Amy Wax and Erwin Chemerinsky. We have presents for you first. We have been listening to these arguments for some 25 years, and it never fails that we always go back and the first thing we say is, can you believe how well that was argued? And, they get nothing for their trouble except for these goodie bags. Anyway, this is on behalf of William and Mary in the law school. I'm just the presenter, but they're here for you. And thank you for such a wonderful presentation. We appreciate it. Our vote is actually 5, 3, and 1. The majority has voted to affirm, and in the majority are myself, Justices Douglas, Liptak, Larsen, and Phillips, and we'll start with Justice Larsen giving the majority opinion for the court.
So we affirm the judgment of the Fifth Circuit. We are not going to revisit Grutter decision at this time, although there's conflicting points and we have some reservations. Stare decisis compels us to stay the course, and we are going to reaffirm the Grutter decision.
Thank you. And then in dissent, it's Justices Savage, Howe, and Stohr, and Justice Savage has our dissenting opinion.
Well, let me see. The three of us in our fictional capacity as justices feel strongly that the majority is wrong. And
respectfully, I assume.
I've got 3 months to write this. All the cases, Bakke and Grutter came up to the court under the assumption, really two premises. One was that diversity was essential on college campuses, racial diversity, and that the only way to get there was to take race into account. This is a different case. In this case, Texas has adopted the top 10% plan forced on the university by a Mexican-American legislator who got this bill through the legislature. An interesting combination of African-Americans, rural whites, and Mexican-Americans, signed into law by George W. Bush, by the way. And over the years, the percentage of minority students has steadily risen. It's now about a third of the students coming in are underrepresented minorities, Mexican Americans and African Americans. 9 out of 10 minority students on the Texas campus today come in under the automatic admit program. Nonetheless, the university has insisted on going back to say, we need to use race, take race into account. I think for very good reasons. You've heard them, improving the class. But the truth is, they have diversity on that campus, and they haven't needed to use race to get there. And there's one point that I think went unmentioned in this argument, and it's something like this, that even though 9 out of 10 minority students on the Texas campus got there based on academic merit, there's still a view in Texas and other places that, oh, a lot of minority students probably got in because of affirmative action. They got a benefit. There's a whole bunch of white parents in that state, and I think the plaintiff in this case, it's very easy to say, oh, I didn't get in because I'm white. It's not true, but I think it's also unfortunate for all the minority students on that campus that the university doesn't say all of our minority students are here based on academic merit. They got no special benefit. And I think it's a cost for the university to keep saying, we need to actually take race into account, otherwise we won't have diversity. They have diversity on the Texas campus, and they didn't need a new race-based program to get there.
Thank you. And Justice Savage referred to his role as a fictional justice, and I do like to remind everyone that since some of us are journalists up here, we are not voting our sentiment. And in fact, Ms. Wags, you should know our track record is really bad. When we compare what we vote to what the justices end up voting, we're really bad. So we're not even predictive in any way. Our final justice is Justice Greenhouse with a separate opinion.
I vote to restore this case to the calendar for re-argument and ask counsel to brief and argue the question of whether Grutter against Bollinger should be revisited, should be overturned. And I'll just say in a brief explanation that I find this a very discomfort-making case the closer one looks at it. I've become persuaded listening to Mr. Chemerinsky that the 10% plan is a terribly blunt instrument that is far from achieving what one would hope it would achieve or what on paper it seemed to promise. And I'm persuaded by Ms. Wax's argument that the core principles of Grutter have become sufficiently attenuated in the way they play out and in the way they relate to the specific situation in Texas that it may deserve reconsideration. So I would vote to give it that reconsideration, and this being so early in the term, I think we can squeeze it into our busy schedule, add it to the January calendar so that it will still be decided during OT 2012.
Thank you. And we're going to take a couple questions before the next panel, but I do want to mention that actually the other comment that was made when we went back into the conference room was that many of us might have bought the argument, the jurisdictional argument that there is no standing here, but we didn't want to come back and just say it's been digged. So that could be a very real possibility for the real justices themselves. We have time for a couple questions. Mm-hmm.
Yeah, I think Dean Chemerinsky brought up a very valid question, the mootness question, or the jurisdictional question, and I'm glad you didn't want to do that. And it's $100 damages. Does anyone, particularly the lawyers on the panel, think there was some bad lawyering here? Because I would think that her damages were more than the admissions fee to go to an out-of-state. So I went to an out-of-state school, state school for law school versus an in-state school for undergraduate. So I know what the difference in cost is. And I'm wondering, does anybody think there may have been some bad lawyering?
Erwin, you think that wouldn't solve the problem, though, wouldn't it? If more damages, it's still...
First is the damages. I really believe there's a serious sovereign immunity problem here as to the constitutional claim.
Yeah.
All of the defendants are the state and Mr. Cassidy.
Yeah.
This is different than Bakke or Grutter in terms of, in those cases, there was a seeking injunctive and declaratory relief. The case that I didn't mention that came to my mind is DeFunis versus Odegaard. The first affirmative action case, they got all the way through argument and then got dismissed on mootness grounds. The plaintiffs get around the mootness by saying money damages, but by making it money damages, you really run into other problems. The place where this has been best developed is an essay on SCOTUS blog by Adam Chandler, and then an article he wrote in the Yale Law Journal on their electronic version, where he develops all of this. And for people who are interested in it, that's really where I got the arguments from. And I'm convinced there's some serious jurisdictional problems in the case.
I know why they didn't ask for an injunction.
Yeah, that's what I was wondering. Why not ask for both? Yeah. Why didn't they ask for the injunction and money damages?
So shouldn't they have sued the regents in their individual capacity to get the money damages?
If this was a claim in their individual capacity, you wouldn't have the sovereign immunity problem. There's, I think, a huge qualified immunity problem, but you wouldn't have that. If the problem with the injunctive declaratory is this wasn't presented as a class action, and it's only one plaintiff. She's now graduated. That relative to an injunctive claim is DeFunis versus Odegaard, which leaves just the money damages of $100.
Do you expect it to go off on that ground, Erwin?
Pardon?
Do you expect it to go off on that ground?
I think there's a real chance that it might when the justices look at it carefully. I think what's interesting is why Texas has chosen to de-emphasize it. If you look at their brief on page 16, there's one long footnote which cites the Adam Chandler article that raises the standing issue. But I can't imagine that some of the justices, especially the liberal justice, they think they might be losing, might not want to say this isn't the right case for jurisdictional reasons.
But the Texas brief in opposition went very heavy on mootness, and the court granted it anyway. So I assume the state didn't want to eat up its page limit by re-arguing something that didn't seem to have much traction.
Given up mootness, but standing is distinct from mootness. I think the money damage claim isn't moot, but I think the money damage claim is the sovereign immunity under Texas Lesage, a different standing problem.
If just one of the 5 conservative justices agrees with you on that, does that mean the petitioners can't win, or do they then go on? Does that justice then go on and say, okay, it's fine, since the rest of the court thinks that this case is not moot, I'll go on and decide the merits?
And keep in mind, I mean, one thing that hasn't mentioned is Justice Kagan is recused. And so you have 8 justices. And so then what happens?
May I ask a different question that Ms. Wax did? One of the things I'm puzzled about this case is if the conservatives have 5 votes to reverse, which I sort of assume that's why they granted the case, I can't understand what Kennedy would say. It's very easy to write a Texas-only opinion that says, Texas had this top 10% plan. See, they've achieved diversity. Now there's no need. But what, they wouldn't want to write a Texas, and you didn't exactly say, well, what should the majority in that situation say? You other states, you can't use an affirmative action program unless you first tried something like top 10?
Yeah, I mean, that I think is a really big puzzle. You know, we have this top 10 plan. We have the facts about the topography of Texas. It might not work everywhere. I think it's very hard to write this as a Texas decision without bleeding over into my broader point, which is one always has to look at the race-neutral possibilities first and, review them. I mean, Grutter did say that, you don't have to exhaust every possible permutation, but I think, now we are not digging that deep to look at other potential proxies, let's say, for race or for diversity and getting a fair degree. So I think it's very hard to say, well, if you have a 10% plan in place, then you can't use race. But if you don't have a 10% plan, you can go to race first. I think it has broader implications.
Because it's like Carter asked that question. It seems that the state would be punished or penalized if they had a 10% plan, where say Virginia doesn't have such a plan.
It depends on how much teeth narrow tailoring has. I mean, the court has to decide what it means by narrow tailoring, and that is the question.
Did you have one last one?
Sorry, one more thing that's troubling me about this 10% plan. It sounds good on paper, and it sounds like it's worked as far as diversity.
Only 3 of us thought that.
Pardon me?
Only 3 of us thought that.
In our fictional capacities.
But what about the issue of discrimination? If Texas or Virginia with UVA, that's a prestigious national university, or pick any other state, adopts one of these kinds of plans to assure its top high school students getting into your Sterling State University, what about the discrimination against everyone from the other 49 states that would like to follow the path of Jefferson, or can come to William and Mary, or whoever, and go to Texas, or the other prestigious state schools?
Can I say something about that? I mean, the possibilities here are myriad, and I didn't really have time to go into it. I mean, a state could then say, well, we're going to look we're going to have a policy of looking at the top 10% or the top 20% of the 5 states around us, or, you know, contiguous state. I mean, the state can essentially do anything it wants. Another point that didn't come up is Scalia's point in Grutter, which is, where's the compelling state interest in, you know, academic proficiency? Why not have a 20% plan, a 30% plan, and then have a lottery? I mean, we get a lot more diversity that way. And the fact that the state is using race means that they don't assign talismanic significance to the very highest SATs that someone can get. They have a broader conception of merit, so that shouldn't really be very costly. I mean, you know, the state, there's so much that a university system can do before they have to resort to race.
Did you have one? Yeah, one last comment.
Yeah, I was just going to comment that one of the reasons Texas is fighting this so hard is that the top 10% plan itself has huge flaws. It started out accounting for about 50% of the student population. It's now gone up to 85% of the population. It does 2 things. It brings students to the campus from widely different secondary schools and widely different college preparatory courses, even though they did well and wherever they were. It has the effect of excluding students from the University of Texas at Austin from the strongest schools in the state, because they're the top 15%. They're not in the top 10%. But if you looked at anything else, they're vastly better in terms of SAT scores and diverse, you know, quality AP courses, whatever you want to say. So the state pays an educational price trying to teach a lot of different kinds of people. It's done that, but it's the reason that they, if they had their druthers, would increase the discretionary group, not just the top 10%, because Linda said that it's a blunt instrument. It's worse than a blunt instrument. It's something that's causing significant academic challenge for the university.
Yet the students have been successful. I mean, there is
those who stay.
I mean,
I know, and I am a graduate of the school, and my daughter was there with the top 10% kids. Some of them stay, some of them don't. Some of them are successful, some of them aren't. But the educational challenge for the school is a significant one.
One last question? Yep.
Just a quick comment.
Yes, thank you.
Isn't diversity more than race? Isn't that part of what they've achieved? People from widely different geographic, educational, and socioeconomic backgrounds. And they are successful. I taught there in graduate school. Isn't diversity at the end of the day more than race? I think that's an important question for ultimately the court and society as well.
Well, as everyone knows, most people here probably know, the case will be argued on October 10th. You'll get to see the real thing. On camera, I'm sure. No.
Don't hold your breath till June. Yeah.
Thank you again, Ms. Wax, Erwin. Really appreciate it. Thanks. We're going to leave our bench, and then the next panel is going to start right away on the Roberts Court. So
No break.
No break.
Let me take our ropes.
Yeah, I got it.
Good evening. You have a treat in store for you tonight. I'm not going to introduce the panelists at any length because each of them is a giant of the Supreme Court bar and one of them also a giant of the Legal Academy. But what I think we want to do is try to make sense of a court that after 7 terms until the last week of June, I think many of us thought we had a pretty good fix on. You know, that last week did seem to scramble some views. I'm going to review the bidding in just a second. But I want to ask the panelists first with brief presentations and then with discussion to try to make sense of did we learn something significant at the end of the term? What do we know about the Roberts Court now that we didn't know then? And how does what we learned, if we did learn anything indeed, tell us about some of the big issues on the horizon, including the case we just heard argued, and perhaps also same-sex marriage and voting rights. To review the bidding, I'm a student of humorous press clippings, and I thought I'd share with you a couple of things people wrote in the wake of the healthcare decision that I found entertaining, and if entertaining, then also probably apt. John Elwood and Eric White wrote in the Green Bag that there's a word for people who accurately predicted that the court would uphold the Affordable Care Act's individual mandate by a 5-4 vote, with the Chief Justice providing the decisive vote and Justice Kennedy in dissent. That word is liars. There's also a word for those who additionally predicted that the mandate would be upheld as an exercise of the taxing power. Damned liars. There's even a word for those who also predicted that the court would nonetheless hold that the individual mandate was invalid as an exercise of the commerce power, but hold that the Medicaid expansion was impermissibly coercive under the spending clause. Well, all we have left at this point is statisticians. And maybe Mike will give us a taste of this also, some of the people on the losing side of the case in the days afterwards really didn't know what had hit them. So Randy Barnett gave an interview in which he said of the Chief Justice, Randy Barnett, of course, one of the architects of the challenges to the Affordable Care Act, professor at Georgetown, says of the Chief Justice, he appears to be the only person in the United States, and certainly the only legal commentator, who holds the view that he announced last week. No one's ever identified that view before. No academic who supported the mandate has held that view. No judge who's considered this case has held that view. No other justice holds that view. This view is unique to Chief Justice Roberts and was unknown until he announced it. And then finally, I want to tip my hat to Charles Fried, who manages to use the most tired metaphor and the most boring way to talk about the court, taking off on the Chief Justice's confirmation hearings in which he compared his role to an umpire. But here Charles Fried says, making fresh use of that metaphor, that many of those relieved at the outcome of the litigation think the Chief Justice called a ball a strike a ball, but at the end of the day, at least the batter was safe on base. So with that backward glance, I wanted to ask Mike for his reactions to that last week and what we see going forward.
Yeah, no, I am not among the liars. I was quite surprised by the result. I think I was real happy at around 10:08, then around 10:09. When Chief Justice kept reading, I got more depressed. We invalidated the law that Congress enacted and the President signed. We did not invalidate the law that was invented by the Chief Justice. And look, I'm not going to belabor the point, but just to echo what Randy Barnett said, no one believes the statutory analysis that the Chief Justice engaged in. Just to briefly review, he identified the test of what was a tax and what was a penalty, and he correctly said the bright line test is whether or not you've made the underlying activity illegal. If you ban cigarettes and say it's a $5 penalty per pack, if you violate this law, that's clearly not a tax. If you say, go ahead and sell cigarettes if you want, but the state's going to take $5 for every pack, that's a tax. And if you look at the statute, you literally cannot conceive of English language clear to make it absolutely manifest that the individual mandate was just that. It was a mandate. It said you shall buy insurance or you will pay a penalty if you violate this legal requirement. If you go home tonight, think for hours and hours, you're not going to come up with any clear language to make something underline it illegal. Why did he do it? What does it pretend for the future? A, I don't know. B, I don't speculate about what Chief Justices think. And C, I never say it publicly if I do have a view. I will say a couple of things about what the conservatives said in the wake of it, or some of them who are trying to spin the decision were saying, look, on the one hand, this is pretty good because we got this really excellent Commerce Clause language and stuff. And I think that's true, I suppose. But everything that was said that was good about Congress's inability under the Commerce Clause to force American citizens to purchase a product was immediately taken away by the tax decision, because they can pass a law that says you will buy this product and the Chief Justice will say that's a tax and it's within the taxing power. So I don't really think it in any way limits Congress to its enumerated powers, as was the original goal of this lawsuit, and certainly those who oppose the act.
the liberals who praised the decision, again, I'm not going to speculate on the Chief Justice's thinking, but I think he'd probably be embarrassed by people who came to his defense and the grounds they came to his defense on. I mean, to the extent I heard people praising the decision, it was, this is really good because a 5-4 decision upholding the law would have been an act of pure partisanship, where an Act 5-4 striking down the law all of a sudden becomes an act of bipartisan statesmanship. I'm not really sure about the arithmetic, and I certainly don't think that the Chief Justice would appreciate the notion that he came to a decision to take the court out of a target in an election year, particularly in the wake of the president, in an, I think, unprecedented act, criticizing the court during its deliberations, because that doesn't enhance the reputation of the court. It certainly doesn't enhance its reputation as a apolitical actor. It makes it look like just another political actor. And I don't think that the court should be perceived as distorting its true views of the Constitution in election years, nor do I buy this notion that conservatives uphold laws and liberals strike down laws, so it's really conservative to uphold laws. That's a cartoon view of judicial activism and judicial restraint. The difference between conservatives and liberals is not whether they strike down laws, it's the basis upon which they strike down laws. Conservatives will strike them down if and only if they are contrary to the text, history, and structure of the Constitutions. Liberals, at least in my view, will strike down laws if they don't agree with the policy results. And it's just as bad, just as much a departure from the so-called conservative view of judging to uphold the law because you like its policy results as it is to strike down a law because you don't like its policy results. What does it portend for the future? I think we're going to find out at least something in the next term when I think the court's going to grant cert in the Shelby County case, hopefully a case that I'm involved with, Nix v. Holder, which challenges the constitutionality of Section 5. We've seen Justice Kennedy in particular, and really the court, a number of cases taking very seriously the structural limitations in the Constitution in a variety of contexts. Separation of powers case involving this board that was created by Sarbanes-Oxley in the Free Enterprise Fund case, U.S. v. Bond, where they talked about the key point that Justice Kennedy keeps trying to make, that if splitting up the atom of sovereignty, both vertical separation of powers and horizontal separation of powers, divvying up the sovereign authority between the states and the federal government, is not done for its own sake, but it's because it's to enhance individual freedom and popular sovereignty, the ability of the populace to control the government and not vice versa. And that issue of whether or not Congress can exceed its bounds will be presented in the Section 5 case, because under the 14th and 15th Amendments, they have the ability to enforce the Reconstruction Amendments. Is this commentary from abroad, or is this...
Somebody wants to... Somebody has a question.
Exactly. So in all events, obviously the question will be whether or not Section 5, which goes well beyond enforcing the Reconstruction Amendments, is beyond Congress's power. I think Justice Kennedy has been quite skeptical, as I say, generally of Congress exceeding its power. I think he's also been quite skeptical in the Voting Rights Act in particular, because he thinks the more aggressive interpretations of Section 5 might well violate the race-neutral mandates of the 14th Amendment. So my prediction would be that, particularly in wake of the Numundo decision from 2 terms ago, that the court's going to say, particularly given the existence of Section 2 of the Voting Rights Act, Section 5 really doesn't bring anything to the table in terms of stopping real discrimination. And moreover, Congress really didn't even try and separate bad actors in the United States from non-bad actors, because they looked at 1968 election results, which would be comparable to Congress in 1965 looking at the Coolidge election. So I think the first tell we'll get in terms of what's happened in wake of the Affordable Care Act decision might be the Section 5 decision.
So I apologize to Mike and to all of you for that noise. I don't know what to do about it. I want to turn to Pam, and each of these questions will in fact closely engage, I think, what Mike's been talking about. right after the decision, Pam described all the ways in which it was bad news for the left. And then in a forthcoming and fascinating forward to the for the term for the Harvard Law Review, Pam talks more broadly about the court's disdain for democracy in many settings. And I think each of those track the first and then second parts of Mike's comments, and I hope you might address each of them.
Sure. So let me step back a little and say two things about the membership of the Roberts Court that people may not have focused on quite so much that I think are telling in where the court is going. The first thing about the Roberts Court is since the retirement of Justice O'Connor, it is the first court in American history not to have a single member who has ever served in elective office at any level. And I think that that plays out in some interesting ways in their attitude towards the elected branches of the federal government. It was striking, I think, this past term, if you look at the oral arguments, I think the Solicitor General's office is taking it in the chops from the court in a way that it hasn't in the past. It's hard to say how much of that is a policy disagreement and how much of that is a change in the court's membership and the court's disdain in a number of different ways for the democratic process and the things the democratic process produces. And I'll say a little bit about that more when I get to the Chief Justice. The second thing about the membership of the court is since the retirement of Justice Stevens and his replacement by Justice Kagan, we now have the first court, at least since the early part of the 20th century, in which there is no overlap ideologically with the justices and the parties of the presidents who nominated them. That is, if you go back to the Warren Court era, there were a number of issues, obviously, on which Earl Warren was far to the left of Felix Frankfurter. If you look at the Burger Court, there were a number of issues on which, for example, Harry Blackmun was to the left of Byron White. John Paul Stevens was to the left of Stephen Breyer and Ruth Bader Ginsburg on a number of issues. And now, in the same way that our politics in Congress has become polarized to a degree where there are no longer overlaps in the Poole-Rosenthal scores, which is just a jargony way of saying the left-right division in the Democratic and the Republican parties, there is no longer going to be any overlap on the Supreme Court. And I think that that is going to make it clearer as time goes on that the court is, in some sense, embroiled in politics, even at the time when the court has less political experience than any court in the past. So I think that membership point is worth keeping in mind, that we have a different kind of membership on the court because they come out of a much more ideologically polarized political process than their predecessors did. The second point comes from a fact that just kind of struck me when I was sitting in my office listening to the tapes of the Affordable Care Act argument. And that was, the Affordable Care Act argument began on the 50th anniversary of the Supreme Court's decision in Baker versus Carr. Which is a sort of odd factoid. But it actually made me think about some of the major differences between the Warren Court and the Roberts Court. And one of these is that for all that people focus on the most important things about the Warren Court being a kind of judicial activism in which it struck down a lot of laws, most of the laws it struck down were state laws. It struck down very few federal laws. And if you had to say, to my mind, what are some of the most enduring aspects of the Warren Court, they were not the transformative decisions by the Supreme Court, things like the reapportionment revolution or the like. Rather, they were the Supreme Court's decisions upholding transformative legislation during the Great Society, and in particular upholding things like the Voting Rights Act of 1965 and the special preclearance provisions. And so I think there's going to be some very interesting reaction this term as we get into the constitutionality of the extension and amendment of the Voting Rights Act. I think that part of what the Chief Justice did in the Affordable Care Act was to clear out space in some ways to enable him to address, without seeming partisan, the issues about which he really cares. And I really think the Chief Justice doesn't give
a rat's ass about the Commerce Clause issues. That is, I don't think that's an issue that he has identified his career with or the like. I think that that's not an issue he cares about particularly. He does care tremendously about some of the high-ticket issues that are in front of the court this year. His hostility in oral arguments in Voting Rights Act cases over the past several terms, and Cannon will remember a case that he and I argued at the court where every time I said, well, Congress, the Chief Justice would say that's dicta. He does not like the Voting Rights Act, and I think he intends to go after the Voting Rights Act this year. He does not like affirmative action. I think he intends to go after affirmative action this year. The spending clause piece of the Affordable Care Act decision lies around a little bit like a loaded gun available for somebody to use in the future, because whatever you think of distinctions like commerce versus manufacture or penalty versus tax, or like the new old distinction, which is the distinction he draws on the spending clause, is one that's infinitely malleable in future cases. So I think that the Chief Justice has taken pretty firm control of the court's agenda, and he is in this for the long haul. The Chief Justice is 57 years old now, I think. He says that his two heroes are Chief Justice Marshall, who managed to do a lot of winning by losing and a lot of consolidation of the court, and Chief Justice Rehnquist, who managed to seed the U.S. reports with a number of statements when he was in dissent or writing solo opinions where no one else agreed with him, that later he came back and picked up in a kind of like crochet where you go back and you pick up a stitch from earlier and you weave it in. So, if I were Mike, I'd be pretty cheerful about the court, but I'm not, so I'm not.
Well, I'm not sure either of you sounded...
We can agree on that.
I'm not sure either of you sounded entirely cheerful to begin with. Carter, how cheerful should we be?
Well, I had a great term, so I don't know how you guys did, but the business community did fine. First of all, let me say I'm not a liar. I did predict all along that they would uphold the Affordable Care Act, but Kennedy would be the swing vote, and that he would do it on Commerce Clause grounds. So I was right on the result, completely wrong on the rationale by which they got there. And I don't think there's much to be gained by trying to speculate about why the Chief Justice comes out the way he does. And I don't necessarily share Pam's view that he doesn't give a rat's ass about the Commerce Clause. My guess is he probably gives at least a rat's ass about it. Maybe not much more than that.
Is that the Latin or
the rat's ass standard?
But I'm not 100% sure how important the Commerce Clause is going to be. I mean, I've been litigating Commerce Clause issues now for a better part of a decade since the Commerce Clause was revitalized. And ultimately, I really did think that Justice Kennedy was going to say, there's just something different about insurance and its relationship to the healthcare market, and it's just altogether different. He didn't go down that way, and so that's very interesting from my perspective. He said, Mike said he thought that we'll get a sense of what this case means in the voting rights context. I think you might actually get a sense of what this all means in the University of Texas case too, because there clearly are two different ways about going at that issue. You can look at a very Texas-specific response to this, or you can deal with it in a much more sweeping way. I think 92 of the 93 amicus briefs said, "Whatever you do, don't hurt me," which is not an uncommon chore for amicus briefs in general, but hopefully will from their perspective certainly drive the court to coming in more narrowly. But we know that the Chief Justice, for instance, seems to be extraordinarily hostile to this. Justice Kennedy has some hostility here, so you would think that there may very well be 5 votes to take a much more aggressive response to this. And then I suppose in that context, the conservatives will say all is forgiven, and that whatever mistake the chief made in this one blip in his career it can be readily overlooked. Beyond that, it is hard for me to imagine that this is going to fundamentally change how the Chief Justice looks at the vast majority of legal issues. I think the other aspect about this is, at least from my perspective, the court doesn't. I mean, everybody tends to focus on the 3 or 4 big agenda cases. Those of us who toil in the trenches and dealing with the issues that nobody else really wants to think about for more than 30 seconds. ERISA, Harbor Workers Compensation Act, those kinds of cases. I mean, the court still handles those kinds of cases the way it always has, and I don't think there's going to be any fundamental change on that. The one thing I will say, and there's no difference between last term and other than this term, everything seems to be a little smaller than last term in terms of the number of cases, is that the court still seems pretty interested in business cases, and I do think that continues to be driven largely by the Chief Justice's background. He comes from a business orientation, and he continues to think about them and worry about those kinds of issues, and he's not enthusiastic about litigation as a method of resolving large disputes. One point I think I've made in this setting before, and I just make it one more time because it continues to linger, is, at least from my perspective, the brooding omnipresence, which maybe you get some insights into, which is, the Supreme Court some years ago announced that they were going to attempt to come up with a relatively clear definition of when the punitive damages can be restricted under the Due Process Clause, and using a substantive due process, which I know Justice Scalia is always amused by that particular phrase, to say that there has to be some proportionality between the compensatory and punitive damages, and that was a 6-3 decision. And since that decision, 4 of the 6 have changed. And if you go to the dissenters in State Farm, that was Scalia and Thomas. And you worry about where Alito and the Chief Justice will be on whether or not they're going to allow the Due Process Clause to impose limitations on punitive damages. And also, you wonder whether or not Justices Sotomayor and Kagan, and replacing other justices who were at least willing to entertain those kinds of claims, might not feel more like Justice Ginsburg did way back when, which was never saw a punitive damage award that offended her. So, and this is an issue the court has now ducked repeatedly over the last 5 to 6 years, and one that I worry a great deal about in terms of at least my clients, and what the future holds on that. And just to tie it back in, you can imagine that there will be at some point a pretty significant debate within the court about what are you going to do with in part going to do it stare decisis because you have the State Farm decision, but in part on probably some genuine reluctance, certainly on the conservative side, to say that we like this notion of substantive due process limiting the size of punitive damages. So that's an issue. It's not on the table again this term. We'll see I'm sure there are a lot of cert petitions that raise these issues because there always are. But it'll be interesting at some point for the court to come back to that.
More generally, Carter, what do you say to those people, and I guess I'm among them, who periodically writes the story that this is a particularly pro-business court? Is that a valuable way to think about things?
No, because there are a lot of cross currents. Plain language interpretations don't necessarily always favor the business community. Federalism principles don't always favor the business community. There are a lot of situations where protecting states' rights places the business community and multiple regulatory regimes in ways that are not particularly positive. No due process limits on punitive damages would not favor the business community. So I think this is a court that unlike the Rehnquist court, certainly in the last stages of the Rehnquist court, does have a sort of more interest in broader business issues, and to some extent has at least some sympathy for some aspects of the business concerns, largely because it doesn't like litigation. Mm-hmm. And so that in that context, it does seem to me that their view of the world and the business's view of the world kind of dovetail quite nicely. But I don't think you can go much further than that.
Where do you guys think that hostility to what is, after all, their trade comes from? Why the self-loathing?
If you've seen people make the sausage, you're not going to be real happy about it. Look, any sophisticated person who's litigated the kind of cases that John Roberts litigated and Carter litigates knows that there's tremendous potential for abuse, class actions,
these kinds of things where the merits are rarely determinative of whether or not the business is settled because they're put in awkward positions. We can go through these cases if you want to bore everybody to tears on a Friday night.
That's tomorrow.
Case by case, but I don't think it's fair to say the court has stretched these statutes. I think, though, they are looking at them with the recognition of the real-world consequences of how sensible economic decisions and fair play to litigants is distorted by some distortions in the system, and they've taken, I think, very reasonable common sense steps to level the playing field to a certain extent. But it's not as if the plaintiff's bar has been, confined to the dustbin of history. So there's a whole lot of litigation still to go.
That's all correct, right, Pam?
If I were Mike, I would think that, but I'm not, so I don't. There are such a range. I mean, Carter's right about this. There's such a range of business cases, and to say that these justices have seen how the sausage is made and therefore that explains them. I actually don't think most of them have seen how the sausage has been made. Virtually none of them was a trial lawyer. Virtually none of them ever represented a plaintiff who'd been injured by anything, certainly not at the trial stages. So they naturally have the view that comes from their biographies. I mean, this is true of all of us. I think we have a view that comes from our biography. And when you have a court on which the justices on the left were not plaintiffs' lawyers. They did not represent people who were victims of discrimination for the most part. They don't have a lot of trial experience. Of course, they're likely to think that trials are kind of messy, horrible things done by messy, horrible people. I don't happen to share that view.
Do you argue, Carter, Mike, differently to this court, which really is, I mean, Pam is indisputably right that its profile is different. Walter used the nice phrase that it's become a court of logicians, that they're very good lawyers, but sometimes seem not to have, sometimes their questions are not grounded in the experience of normal human beings.
I don't know. That reminds me of a question Justice Breyer asked me once in a bankruptcy case where this was the first year he was on the court, and so he didn't know me from Adam, and he asked me about my vast bankruptcy experience, and my wife laughed out loud in the courtroom. Not sure I'm the guy who's going to actually be able to bring him the reality check they're looking for. I mean, I don't think there's some aspects of what you write in the briefs that has changed fundamentally over the time I've been practicing law, to be sure. I mean, the whole question of statutory interpretation has been revolutionized. It wasn't that long ago. You could read whole opinions of the Supreme Court and find out that there was actually language in the statute and a footnote on the 14th page of the opinion, because the court was analyzing everything except the language of the statute. There's no advocate in the Supreme Court today who would do anything other than begin with the language. So, clearly that's a fundamental change in how you advocate in this court. On constitutional issues, you got to, and the other thing is you've got this embarrassment of trying to figure out what do you do with legislative history, because that as soon as you get to legislative history, there's some number that never been exactly clear to me how many people, certainly one, is going to stop listening and reading, and maybe more than that, and you certainly don't want to stand up at oral argument and make use of legislative history, because that one person will immediately call you out on it and say that what is that worth anything, which doesn't exactly help you move. Whereas I can remember oral arguments where we spent lots of time talking about legislative history, although it was always seemed to me a little difficult to engage somebody on what was in a committee report and such and such. But a lot of times it happened, and the justices clearly paid attention to it many years ago. So all those things have changed pretty dramatically. And of course, the other thing that's changed pretty dramatically is that the number of questions has just gone through the roof, and the number of words spoken by the justices as opposed to the words spoken by the lawyers has changed pretty dramatically over the course of the last 25 years.
Yeah, I don't want to echo what Carter said, but he's clearly right both in terms of how they approach legal issues on statutes. I'd extend it really to the constitutional questions as well. I mean, Heller, for example, I mean, you've never seen such delving into originalism on all sides of the issues that the gun case. Whereas back in the 80s, Carter knows better than I do. Everybody was talking about, modern mores and how we're going to translate this 18th century obscure idea into a modern evolving society, and you don't see any of that anymore. At least not in such a straightforward kind of way. They're all keenly lawyers. They're very smart, very well prepared, and they're going to. The Justices Breyers of the world will obviously say that policy consequences matter to them, but that is the third thing they'll think about instead of, as Carter was alluding to, in the 80s and 70s, that was the first thing that a substantial segment of the court was thinking about. So, yeah, it's dramatically changed, and they've been around for a while. We obviously have 2 new members. But at least in terms of the 5 votes that I can ever hope to get, you're looking at, you've seen Justice Kennedy, he's a very strong proponent of the First Amendment, for example. You know that a substantial segment of the court doesn't like paternalistic rationales for limiting speech, doesn't like speaker-based discrimination, and so you can gear in more directly on the kinds of things that you've noticed in the past and draw more precise analogies. But that's just because a lot of these folks have been on the court for quite a while, and you can get a relatively decent sense of their jurisprudence.
They're so selective in their originalism, though. It's really kind of staggering. And the race cases, for example, the originalism just goes out the door entirely.
On what planet?
On what planet? Read the 14th Amendment.
Yes.
Read the 14th
Yes,
Amendment.
it says equal protection.
No,
No,
it says Congress. It doesn't say anything.
I've been trying to provoke this for a long time.
It says Congress for a reason, which is if you go back and look at why was Congress expressly delegated the power in the 14th Amendment, because they didn't respect the Supreme Court. They didn't think the Supreme Court had a commitment to equality.
Is that not so? Is it not a reaction to Dred Scott?
It says enforce. They can enforce away the 14th and 15th Amendment. What they can't do is create statutes that are entirely different from the 14th Amendment.
You read enforce as a limit. I read enforce as an empowerment.
That's because I'm familiar with the English language. Which says enforce means they can enforce things that are involved discriminatory purpose. What they can't do.
I'm bilingual too. I speak English.
In all events, I don't. It's not fair to suggest that they throw out their originalism to achieve.
Sure, it is. Sure, it is. That's exactly what they do. They throw out their originalism to reach a policy result, and it's obvious that a Congress that proposed the 14th Amendment thought they could take race into account because they did take race into account. So the idea that the 14th Amendment is colorblind is just untrue as a matter of originalism. You can make it as an argument, but it's not an originalist argument. And, even Justice Scalia kind of recognizes that he's a faint-hearted originalist. He says in Heller, for example, I'll just use one example here from Heller, which is he says, well, how do we know that the kind of arms you can keep and bear today are are revolvers and pistols that people have in their house, even though those weren't the kinds of arms people used in 1868, because they're the kind of arms most people use today. Well, I went back and I looked at the Center for Disease Control stuff, and it turns out more women in America have had abortions than have handguns. So why don't we redefine liberty in the same way to say this is a liberty that lots of people exercise today, and that's how we know that that's what liberty means for us. The answer is because...
I will pay for you to make that argument at the court.
No, because I do not want to be like Larry Flint, hauled out of there in chains. I'm just making the point that words and the decision about at what level of generality to talk about the words are a decision of judgment, and different justices will make different decisions on these things, and it's not that one of those sets of decisions is principled and the other set is unprincipled. They come from different commitments and different understandings of the words. So you know, when I argue in front of the Supreme Court now, I mostly get depressed. You know, and I'm a very optimistic person, as those of you who know me know. But yeah, I mean, I am an optimistic person. I have a picture of Hubert Humphrey, a signed photo of Hubert Humphrey on the wall in my office. That shows you what an optimist I am, right? You know, the happy warrior. But I do think the question is, as we get much more polarized politics and the two parties draw further and further apart, and there's less consensus and there's more bitterness, the Supreme Court sees that, and of course they don't really like that process, and so they lose a little respect for that process. But again, it's selective, and I'll just give one example here, which is the court is very robust on campaign speech, and they said,
I finished the
I just want to, which is the Supreme Court says in Citizens United.
But when the little guys are hurt through voter ID, okay, go ahead.
No, but the Supreme Court says that people will not lose confidence in the election process because lots of money is spent in the process. So we should allow people freedom of speech. But the court has decided that voting is not speech, and therefore it's not First Amendment protected. And they've issued a series of opinions that say people will lose confidence in the election process if we don't have voter ID. There's no empirical support for that at all. And the two things strike me as quite parallel. Now, you could have the same view of both of them, Justice Stevens did. But most of the justices don't have the same view. That is, they're prepared to allow regulation of one and not regulation of the other. And we might ask, why is that? Why do they see the world so differently from each other?
Mike, why do they?
Let me count the ways. Citizen United said you can't restrict one citizen's speech to bring it down to the level of all others. That was an opinion that was joined in by Justices Brennan and Marshall and Buckley v. Vallejo, where he said the notion of limiting some speech to enhance others is wholly foreign to the First Amendment. So, obviously, any effort to restrict speech, to ban speech, is bad. Now, let's compare that to voter ID. Is anybody being banned from voting? No. They're simply asked to prove that they say who they say they are. Now, the analogy, therefore, would be to ask a corporation to file some papers proving who it is. That we've upheld all kinds of restrictions like that, indeed far more onerous restrictions, including disclosure restrictions.
So you're not going to go and challenge disclosure?
In Citizens United, as you know, they upheld the mandatory disclosure provision. So difference number one is a ban versus a non-ban. Difference number two, Congress shall make no law restricting freedom of speech, whereas the Elections Clause says the time, place, and manner of holding elections is given to the states. So they can tell you that before you vote, you have to register, and they say you have to go here to vote. We all know that they couldn't tell you before you speak publicly about things, you have to register with a government agency, and you can only do it in a particular place. So the government's control over the process, after all elections are run by the government, is entirely different in the voting mechanism than it is in the free market. Finally, what are the evils that we are addressing? The alleged evil we are addressing under Citizens United is there will be too much speech, that corporations will drown out people. Pam talks about the lack of empirical justification. Tell me anybody who can say with a straight face that corporations since 2010 have drowned out alternative voices. Tell me anybody who can say in a straight face that McCain-Feingold from 2002 to 2010 restored Americans' confidence in the public integrity. This was the golden age of Pericles, where everyone said, gee, money no longer matters. I've never seen a law fail on an empirical basis more obviously. So the evil in Citizens United is people will speak. The evil with somebody voting who doesn't have a proper ID is that they will fraudulently cast a vote, i.e. they will cancel out a legitimate voter's vote. Everyone agrees that that's fraudulent, and no sensible person should agree that too much speech is bad. So there are three differences why you might take a slightly different approach to Citizens United than you would to voter ID.
I don't deny that there are differences between voting and political spending. My point is a slightly different one, which is that the court is prepared to deny people the right to vote on the grounds that public confidence should overcome a fundamental right, and they're totally uninterested in thinking about regulation of political spending on the same rationale. Now, the other thing I think is really interesting is that the people who said, don't regulate, just disclose, have now turned around and they're attacking the disclosure provisions because they don't want disclosure either. Mitch McConnell used to say, just have full disclosure, that will solve everything. And since he's gotten everything else struck down, he's now turning around and saying, maybe we shouldn't have so much disclosure either. And I really do think that there are some serious threats to the fabric of our democracy. Would I regulate people's speech? Very little. I would regulate very little of their speech. It's not so much that I'm saying that there should be more regulation. I'm just pointing out the inconsistency of the amount of voter ID in this country. Paul and I litigated one of the voter ID cases at the Supreme Court, and the state of Indiana was asked in deposition, do you have a single documented example of someone pretending to be somebody else at the polls in the state's history? And their answer to that question was, no, we do not have a single documented example. To which the response was, that must mean there's lots of fraud because it's so successful. I mean,
Actually means I should have asked Illinois.
Can
I respond to this point?
Of course.
The plaintiffs in Indiana were asked to document one person who couldn't vote because of the absence of ID, and the answer was zero.
Well, we had
now,
8 nuns in the first
election.
election after it went in. 8 nuns, retired nuns, showed up at their convent to vote. The election official was a sister of their order, but because they were retired nuns who shouldn't be driving anymore, they had expired licenses and they weren't allowed to vote.
Respond, but let's not go wholly off the rails on voter ID here.
This will be my
Should
last.
we talk about same-sex marriage instead?
Actually, yes.
No. Very quickly, this notion that there's no documented instances of voter ID. Assume with me that we had never, ever checked bags coming through customs until today. And then we decide, you know what? People might be smuggling stuff in bags through customs. Everybody would say, well, document for me all of this smuggling that's going on in the past. And you would say, we've never looked, so we don't know. But it's certainly a reasonable apprehension that it's going on, and we need to stop it from happening, not only because of the reality of fraud, because of the perception of the fraud. I worked at the Justice Department. There's no documented instance of anybody bringing a bomb in or blowing up anybody in the Justice Department. But all of these people who are plaintiffs in these cases can't get into the Justice Department, Eric Holder's Justice Department, because they need an ID. Because Eric Holder recognizes that sometimes prophylactic measures to ensure against bad behavior are part and parcel of it. So I fully agree with Justice Stevens.
But notice
that it's not a serious burden and it serves an important
But
purpose.
notice this, Democrats and Republicans both agree we should bomb check, and Democrats and Republicans both agree we should have a customs service. But Democrats and Republicans have very different views on voter ID.
Because you fraudulently steal elections.
Let me save the questions for the end. Ask about the Voting Rights Act, which I think at least 2 of you have alluded to. What is the fact that we have one answer in a non-covered jurisdiction on voter ID and seemingly a different answer in a covered jurisdiction tell us, if anything, about the future of Section 5?
It's very telling that Attorney General Holder, who compared voter ID laws to poll tax, has not even tried to bring a Section 2 lawsuit, which, as you probably know, prohibits activities with a discriminatory result. The only time they've ever objected to it is in covered jurisdiction. Nor, as far as I know, has any plaintiffs group brought it in non-covered jurisdictions either. And when the Texas decision that struck down the voter ID, even the 3 judges who struck down the law agreed that there was no reliable evidence of a racial disparity in terms of identification possession among blacks, Hispanics, and Anglos in that case. And I think that vividly illustrates that
admittedly abominable behavior, but abominable behavior that occurred 30 to 40 to 50 years ago in the South. We have imposed on them a mark of Cain where now they are treated differently when no rational person, I don't think, can argue that the situation in Arkansas, a non-covered jurisdiction, is materially different from Manhattan, for example, which is a covered county. And I think one of the problems in Section 5 was Congress in 2006 had an opportunity to update its formula for determining which jurisdictions were covered and which weren't, and it engaged in an act of willful blindness and affirmatively refused to use these measures again to figure out whether the current burdens are justified by current means, precisely because they knew that the former states of the Confederacy that are covered by Section 5 would look no different, materially different than the other states that are not covered by Section 5.
Well, this isn't the place in which to get into a long discussion of the empirical differences and disagreements, but I disagree.
Pam mentioned a second
If I were Pam, I would agree with that.
Does that mean you read all this?
So before we turn to questions, I did want to touch on same-sex marriage and talk a little bit about whether they take the DOMA case and whether the states' rights aspect of the DOMA case makes a difference in the court's analysis.
Well, it certainly hits the sweet spot for Justice Kennedy, which is a combination of his general views in favor of reducing barriers for LGBT people and his affection for federalism. And it allows him, I think, to decide a case that doesn't require him to go back to your Arkansas and Alabama point, to require Arkansas and Alabama to allow same-sex couples to get married, but allows him to say something about the rights of people in states that are prepared in their political processes to recognize marriage. I mean, I represent a client at the Supreme Court in one of the DOMA cases whose marriage is recognized by the state in which she got married, but who was socked with $300,000 in federal estate taxes because the federal government doesn't recognize the marriage and treats the passage of her deceased spouse's estate to her as if they were just giving it to a stranger. And especially for justices who like money, you'd think this would be an especially appealing sort of case for them. I mean, why shouldn't you be able to
We have a big deficit.
There's rationality review for you. We'll just balance the entire federal budget on the backs of wealthy gay widows and widows. Who knew? No, I mean, I think if the court takes the DOMA cases, and I expect they will, I expect them to hold that DOMA is unconstitutional. I'd be very surprised if they hold that DOMA is constitutional.
All right, I've kept you waiting for a long time, sir. I'm sorry.
First of all, I was just going to follow up on something that is, is Carrie? How do you pronounce it? Carlin?
Which one of us
the
is
one
it?
lady up
Irvin
there.
Carlin?
The one lady up there.
Well, that must be me.
I don't want to mispronounce your name.
It's Carlin.
Carlin. This is Carlin. This is Carlin. Your friend that, your client that passed away, I guess she should have gotten behind.
She didn't pass away. Her spouse passed away.
Her spouse passed away. Should have gotten behind the extension of the estate tax repeal that George Steinbrenner conveniently died the last year we didn't have estate tax, which kept the New York Yankees intact for the Yankee fans. On the voter ID, I just want to mention, for the benefit of the out-of-state people that are here in the audience and on the panel, that you're sitting in a state where, as I just got mine in the mail, and I hope the rest of my Virginia colleagues did as well, we got a valid ID in the mail, free from the State Board of Elections, that tells us where we go vote and allows us as a valid ID to vote. That little white piece of paper you got in the mail is a valid ID.
That's terrific, but let's talk
But
some
it's
more about
still a valid ID under state law.
We're discussing a picture ID. Some people can't.
Yes, I see a question back there.
I have a question about something that was said at the very beginning about the Roberts legacy, the Roberts court, so back to that. I was wondering, the observation about how there's sort of a distrust of politics or about the democratic process is really interesting. And I was curious if you thought that distancing from politics in general had something to do with the chief's decision in the ACA opinion. If he was trying to do the least amount possible, I'm just asking if you thought that played into your theory or if that's something different.
Well, the thing I thought was really fascinating about his opinion is it's the most grudging opinion upholding a statute I've ever read.
Yeah.
That is, he's got a thing at the beginning of his opinion. He has this nice little civics lesson at the beginning of his opinion. And at one point in the civics lesson, he says something like, you know, it's not our job to save the people from the consequences of their political choices.
VA versus Hill.
And the liberal has a little bit of that.
Yeah, I mean, and it's a way of saying, you want to be, you know, the political process is filled, you know, and then there's the sort of, in holding that this is a tax, it allows him to kind of get a couple of digs in on, you know, the president and Congress insisted it wasn't a tax, but I'm such a smart lawyer, I can explain to you why it is a tax, and therefore why I'll uphold it on grounds that aren't really the grounds that the people who wanted to have it upheld on. Yeah, I mean, it does play in that way. The tone of the opinion is really pretty fascinating. But they do this in a lot of the other cases as well.
So that was a tonal point, but,
Yeah.
but there was a substance part to that question. It was strategic?
I don't know, you know, I don't know. The Chief Justice is a very smart guy. I have no insight into him at all, unfortunately, which turns out to be a problem for me given my line of work. I don't think, you know, that he throws cases or stuff. I mean, I don't think he's being dishonorable in some way, but I think he has the long view. Just as Chief Justice Rehnquist, who was his boss, had the long view, which is you don't have to pick all the pieces off the table at once to move the law in the direction you're hoping to move it. And I think he seldom says anything that by accident.
Yes.
I want to speculate on the possible implications for Title VI, Title IX, Section 504, and other discrimination laws that follow federal money of the language in ACA about the spending clause.
Well, I mean, I have to say that as a practicing lawyer, the spending clause ruling was probably the best news in the opinion, since there are going to be lots and lots of cases. I mean, every so and the part about that part of the decision that's the most startling to me is that it's 7-2. It's not the 5-4 ideologically driven decision. The metes and bounds of what constitutes coercion in this context is utterly unknowable. It's sort of like the glue of class actions the term before. You know, is how much glue it keeps them is enough to keep them together. When, you know, those are tests that, again, as a litigator, I couldn't be happier with. But as a litigant, I suspect I'd probably be less than enthusiastic. I mean, clearly, to my mind, the Commerce Clause issue at the margins has some significance. The taxing thing is probably never going to be seen again. The spending clause issue, to my mind, is the single biggest part of the ruling going forward in terms of creating a significant amount of it, certainly litigation and probably a fair amount of debate, and it will affect Congress. You know, every time they're going to extend the statute, they're going to have to take a hard look at whether or not how much they're going to want to fight that fight.
Do any of you have an
Could I just ask
yes.
Carter a question about that? Because you also argued Douglas against independent living, and I wonder about the interaction between the court's spending clause decision here and the question of who's going to be able to enforce the spending clause going forward if you take the kind of Chief Justice's dissent there.
Yeah, well, that'll be a serious problem, although the states probably will always have some ability to go in and challenge it. So it'll be, you know, unfortunately, I guess now
I mean, it'll be two kind of limits on the
Right.
spending clause,
Exactly.
right? One is people can't enforce it, and the other is the kind of new-old distinction as opposed to the coercion distinction. It'll be really interesting to see when does something become a new program if you add an additional condition to it or the like.
Just I was convinced of two things going into the ACA arguments. One is nobody was going to take this taxing power argument seriously, and the spending power argument was DOA. So this will show you what
You're an honest man.
Nostradamus I am in terms of predicting how this comes out. And I can only echo Carter. I really can't figure out what the rule is or the dividing line. And other than people who get paid by the hour, who are going to be very happy with, it's going to make the punitive damages look like a really bright line rule from now on. I really don't know where you would draw that line.
Lyle.
I wondered what your perception was about the retirement of Justice Stevens. Some of us had the impression that Justice Stevens operated in something of a restraint upon Justice Kennedy's conservatism. And Kennedy appears to be moving more to the right. And I'm wondering whether or not you think that that's in any way traceable to John Stevens' departure.
I don't think he moved to the right. I don't think he moved to the right this term overall. I think if you focus on the healthcare case, it looks like he moved to the right. But look at his right to counsel cases, the plea bargaining case that he wrote. Look at his, the juvenile LWOP case, the Arizona immigration case. He's not somebody who's moving in a particular direction.
I don't think he's. I think you can go subject by subject, really, just to echo what Pam said, and I think he's made it clear what he's quote conservative on and quote more liberal on. I don't think he's a guy who tries to split the baby. I think he's got certain views that fall within, the stereotypical ideological left or right views, but he tends to be more of a mix than some of the other justices. But I haven't seen him, and again, I'd be interested in Carter's view, I haven't seen any evolution over the last 5 or 6 years that's different from what you had seen previously.
No, the thing that's fascinating to me, and it's sort of just the difference in styles, is that Justice Kennedy is perfectly comfortable getting a 5-4 ruling, regardless of which way it goes, as long as it's the way he views it, and then write it in a very sweeping and somewhat majestic way, whereas typically the Chief Justice seems to work at it a little differently. He tries to get to, if he's only got a 5-4 vote, he seems to go somewhat more narrowly in the way he approaches it. To get back to your
I'm sorry to hijack your question.
No
but compared to O'Connor too, I mean, she seemed to be more of,
even more
right.
Clearly, it's exactly where she would go.
Does it make any difference that when he's with the liberals now, he's assigning, whereas Stevens used to assign? Apparently not.
No, I think we're all trying to think of an example.
Well, so
where it would make a difference.
Where
it would matter.
The only big 5-4 that he assigned away this year was LWOP, right?
To Kagan.
Yeah.
Yeah. So I don't think he's used that very. Rehnquist, you could point to some examples where he'd done that, but I don't see Roberts having done that.
Oh, there's one topic I wanted to get your thoughts on. Why don't they work harder? They decided 65 cases with signed opinions last year. What do you make of that?
And they won't decide Carter's cases. That's the other thing, right?
They get paid the same whether they decide 65 or 165.
Yeah. But right, I mean, I was waiting for the Fox decision all year, and there was a couple at the end. They clearly just said, "Oh, the hell with it."
We ran out of time.
First American.
Right. I mean,
And does it affect your practice, or maybe this is a criminal point that it must.
The conduct is criminal.
No, I understand that. But the per curiam decisions, and there's a real rise in them, probably makes seeking cert kind of a dangerous business because you don't know whether you'll get merits briefing or whether you have to make your arguments on cert.
Yeah, but you can usually tell whether the case is a candidate for summary reversal or not. I mean, at least the ones I've looked at, and KPMG happened last term. Client really wants to go up, and you don't have a square conflict of one sort or another, but it's an outrageous result. You'll make the pitch for it, and you'll probably make it in a merits-based way, and hope the other side bites and offers up a merits-based response, and therefore the court feels reasonably comfortable acting summarily.
Finish the work that they take on in one term. This term, for example, they had the West Virginia redistricting case. It was fully ready. They sat on it all summer long, and then last week, issued a per curiam opinion.
Lyle, remind me, they stayed it right on the last day. They stayed, and when they had time to write that short opinion, I guess, right?
No, I know, it was only 8 pages long.
Yeah.
For God's sake, does it take to write 8 pages?
Yeah. Well, in Fox Television, it took a long time to get 12 pages, and 8 of them were just the
Look,
facts.
it took him from the November sitting until the last day to dig First American.
So,
right?
All right, why don't we do 1 or 2 more questions and we'll call it a night? Yes, sir.
I'd like to hear the panel's response to how significant the Lutheran Church School case, which was unanimous. And I remember last year at this conference, the overwhelming majority was that the Supreme Court would require the Lutheran Church schools to comply with the ADA. And it turned out just the opposite. Does it have any
that's your area. It's not mine. I don't do religion cases.
I'm not Lutheran. Yeah, no, we know which case it is.
They know the case, they just don't know what to say.
It seems so long ago now.
The result to me was not.
What was significant about it was the way the court reasoned. Is you don't see the compelling state interest test, thank God, in the opinion. And of course, that's what had been plaguing the whole free exercise of religion litigation. Was the compelling state interest that was in and now it's out. And everybody thought after Smith too, there was nothing left of the free exercise clause. And I'm just wondering whether you think that's a sign here, because after all, it's the ADA, the Americans with Disability Act. Why shouldn't it apply to a church school, especially when the teacher was teaching a secular subject, as everyone likes to?
Well, I mean, 2 points, right? One is, I don't know what the panel said last year, but I think it was generally received wisdom going into the case that some ministers, the Pope, priests, are beyond the reach of non-discrimination laws in terms of who the church decides to sanctify as a cardinal. The question was the difficult one of figuring out where to draw that line. So I think in that regard, as a relatively fact-based decision, the Justice Department took a very strange review that was rejected 9-0, that the free exercise clause had no relevance here. You would just apply sort of general associational standing. But you have put your finger, I think, on the interesting jurisprudential aspect of that case, which was, as you point out in Smith, they've basically replaced the compelling government interest standard with sort of a non-discrimination rule. And when they're talking about free exercise of religion, taking peyote in that case, an individual exercise in religion, but when it comes to the organizational autonomy of religious institutions, they're not using a non-discrimination principle. They're using a does it go too far into the church's decision making, and they explain that in about 3 sentences. I'm not a huge fan of Smith, and I didn't find the explanation particularly compelling. But it's interesting, the dichotomy of treatment in these cases.
Well, I would think you're going to see it raised in the cases involving the mandate on contraception and abortion, because
I'm doing those cases and they have been raised. Yeah, exactly. So,
That's a nice point. Thank you. One last question back there.
You mentioned First American. Do you have any insights on why they decided to dig it and why it was so late in the term that they did that?
I don't have any insight exactly into why they decided to dig it, except my guess is that the justice who was assigned to write the majority was writing too broad and sweeping a majority in some ways, and the court began to fracture over what counts as injury in fact. Because at the oral argument, the Chief Justice, I think people had always thought in the past that the kind of contrast was injury in fact versus hypothetical injury. And the Chief Justice floated at oral argument the idea that the kind of antinomy was between injury in fact and injury at law. And that sort of suggested that Congress could really only convey standing for common law style injuries and not for kind of private attorney general style actions. And my guess is that the court took the case thinking it was going to issue something very broad, and then they just couldn't coalesce behind something very broad, and so they gave up at the end of the term. But I don't really know.
So needless to say, there's no better note to stop on than First American. Please, please join me in thanking the panelists for a really lively discussion.